I'm Catherine Pruitt, a board-certified Texas family law attorney and founder of Pruitt Law Group. If you think you may be headed for a divorce, it's important to get your legal advice from a qualified family law specialist, as there's a lot of bad information out there. In my last video, I debunked 3 Texas divorce law myths. Today, I'd like to tackle a few more. The first myth is that you have to prove that a spouse is at fault to get divorced in Texas. This is simply not the case. Testimony by one spouse that the marriage has become insupportable and there is no reasonable expectation of reconciliation is sufficient to obtain a no-fault divorce in Texas. A spouse, unfortunately, has no legal duty to reconcile with the other spouse. Other no-fault grounds respected in Texas are living apart for 3 years or confinement by a spouse in a mental hospital. Fault grounds for obtaining a divorce include cruelty, felony conviction, and abandonment. If a fault ground is proven, that could support the court awarding more than 50% of the community estate to the innocent spouse. Which leads into the second myth. It's a common belief that since Texas is a community property state, the community property and debts are always divided 50-50. This is simply incorrect. Community property is divided in a just and right manner, taking into account several factors, just a few of which include 1, whether a spouse was at fault for the breakup of the marriage, 2, which spouse has custody of the minor children of the marriage, 3, differences in earning power between the spouses, 4, the age and respective health of the spouses, and 5, whether a spouse has significant separate property assets outside of the community estate. These are just a few of the factors which could warrant the court awarding more than 50% of the estate to one spouse or the other. If you'd like to learn more about these factors, please be sure to consult with a board-certified family law specialist. The third myth is that if the parents share possession of the children on a 50-50 schedule, then no child support is paid by either parent. This is not always the case. The courts will often calculate what each parent would pay the other in monthly child support according to the Texas guidelines set out in the Texas Family Code, and the higher earning parent will pay an amount discounted by the amount the lesser earning parent would pay. For example, if the parents have one child and the higher earning parent would be paying the lower earning parent $1,800 per month, and the lower earning parent would pay $800 per month to the higher earning parent per the guidelines, then the higher earning parent would pay a discounted child support amount of $1,000 per month to the lower earning parent. With that said, though, the courts have the power to award no child support or full guideline child support if the court finds that it's equitable and in the best interest of the child. If you're contemplating divorce, it's important to consult with an experienced divorce attorney so you do not make the mistake of negotiating or even reaching unwise agreements based on common Texas divorce law myths. At Pruitt Law Group, we educate our clients and come up with a strategy that maximizes our clients' results. If you're contemplating divorce, call us today to schedule a confidential consultation.